If the 17th century was the story of a political struggle between the king and Parliament, then the victory of Parliament marked a new era in British governance. With sovereignty now firmly lodged in king and Parliament, judges underwent a transition as well. In order to understand what this means, we will want to talk about three things: judicial independence, parliamentary supremacy, and statutory interpretation. The tenure of judges has always been an important question. The judges were traditionally the servants of the king, paid by the king, and removable at the pleasure of the king. This was an insecure tenure at best, although it is notable that there is no strong records of judges being removed willy-nilly in the 14th and 15th century, even if they did hold their tenure at pleasure. This is because the judges were keepers of the common law. The common law was mysterious and unknown to any but themselves. As such, there is actually a good record in medieval times of the judges ruling against the king and no retribution by the kings against their judges. In the 17th century, conflict occurred between the Stuart monarchs and judges on a few notable instances. In 1616, King James I summoned the judges, all of his royal judges, common law judges of the central courts, before his privy council to answer whether they would stay a suit. That means to stop a suit, if the king ordered them to do so. Every one of the justices said yes, except for one, Sir Edward Coke. Coke was the Chief Justice of King's Bench, and he was removed several weeks later by the king. He would, of course, by the way, show up in Parliament during the 1620s, and he was, of course, one of the authors of the Petition of Right. Charles I, James's son, also removed several judges, and by this point it became clear that the monarchy was attempting to make the judiciary a subservient arm of royal policy rather than independent keepers of the common law. The answer to this, and it's not an answer immediately decided upon, but the answer is to give judges a life tenure. And the correct words of the limitation in this case was quamdi sibini gesserit, during good behavior, so long as this person behaves well, is the more literal translation. This tenure was given with some offices before the 17th century. Notably, by the way, all the barons of the Exchequer already enjoyed this tenure. But in 1642, Charles agreed to appoint judges during good behavior, and the practice was followed after Charles II was restored in 1660 for a time. But beginning in the 1670s, Charles quietly began to issue patents for judgeships, again at the pleasure of the king. He also began to suspend judges, which meant that they could keep their salary but not participate in hearing cases. So even those, in other words, who had life tenure under good behavior could find themselves suspended and replaced with court favorites, which is precisely what Charles II did. And James II removed 12 judges in 4 years, all over that disagreement over the suspending power. William, when he comes to power in 1689, agreed to appoint judges according to good behavior. The Act of Settlement, passed in 1700, guaranteed that judges would be appointed for life with the during good behavior limitation only. Curiously, this left only one potential problem. When one monarch died and another succeeded, all patents had to be called in and reissued. It was possible that at that point, a new monarch could refuse to reissue a patent for a sitting judge. By 1760, parliamentary statute eliminated this possibility, securing life tenure for all sitting judges. Thus, we can see that there is both a long tradition of judicial independence and a history of conflict. The conflict was settled more or less in the 18th century, and judicial independence from the policy-making arm of government was secured in Great Britain. Note that judges in the colonies, by the way, still held their patents at the pleasure of the royal governor, making judges there far less independent right up to the Revolution. Parliamentary supremacy is, of course, part of the story of judicial independence. It was statutory law that secured judicial independence, that is, the universal tenure at good behavior. But we have to remember that this as well, this parliamentary sovereignty itself, also impinged on the power of justices. Remember that Parliament and statutes have a long history too. Parliaments were not called frequently in the 15th century. When called, they often issued specific statutes that dealt with specific grievances. There was very little policy making that went on. Parliament's share in government rose in the 16th century, oftentimes as an arm of royal policy and sometimes as a counterweight to it. But importantly, the number of statutes issued that directed the law increased. The number of statutes that Parliament passed which directed the common law, provided remedies, new remedies, changed old remedies, this increased. In the 17th century, this increase in statutory law still did not threaten common law judges. The common law was largely independent of statutory law. Nonetheless, there were some clashes, and they produced substantial ambiguities. One of the most famous was Dr. Bonham's case. Dr. Bonham was a physician, and he sued leading members of the Royal College of Physicians in London for having fined and imprisoned him without legal authority. Chief Justice Edward Coke, yes, that Edward Coke, same guy, ruled for the doctor. When he dealt with the statute that established the authority of the Royal College of Physicians to fine and imprison its members, Coke wrote that, quote, "It appears in our books that in many cases the common law will control acts of Parliament, and sometimes adjudge them to be utterly void. For when an act of Parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it, and adjudge such act to be void." On first reading, it might appear that Coke was making an early articulation of the doctrine of judicial review. And here I'm not talking about the judicial review of judicial errors, which we spoke about in a previous week. What I'm speaking about here is the right of the judiciary to control acts of the legislature and their ability to strike them down as unconstitutional or as against the law. But there are substantial reasons to doubt that this is what Sir Edward Coke is doing. First of all, it is an anomaly. No other judge would ever suggest, or ever did suggest rather, in the 17th century, that judges could strike down acts of Parliament, and Sir Edward Coke never said so on any other occasion. Second, the way the opinion is written suggests that Coke might have meant something different than the modern interpretation provides. He may well have meant that the courts were not bound to follow a statute absurd upon its face. Given that the rest of his opinion in Dr. Bonham's case is about interpreting the statute rather than simply disregarding it, this may well have been what Coke meant. There is another possible reading. Sir Edward Coke was, throughout this period, defending the common law courts from attack, and I haven't really been through the history, but he gets into a fight with the Lord Chancellor about conflicts between equity courts and common law courts. And of course, he's the one who stands up to James and says, well, judges enforce an independent king's law. So he fights with Chancellor, he fights with the king. It could well be that he was fighting Parliament as well. If this is the case, it is more notable here that Coke lost the argument. The case, and by the way, would disappear from memory after a half century. It would not be resurrected until the American Revolution. Importantly, Dr. Bonham's case would be cited by James Otis in his attack on the writs of assistance. So it is possible that Coke's words took on a new meaning in the 17th century with big implications for American constitutional history. But in Great Britain, the trend had moved decidedly towards parliamentary supremacy, and as such, sovereignty was settled in king and parliament, and with this sovereignty came legislative supremacy. Sir William Blackstone, the greatest English lawyer of the 18th century, put it this way. First, he declared that statute law was the supreme expression of the sovereign will, and that it was supreme to common law. Next, he actually makes the same exception that Coke cited, that absurd statutes were of no force. But shortly after he claims this, he goes on to add this. I lay down the rule with these restrictions, though I know it is generally laid down more largely, that acts of Parliament contrary to reason are void. But if the Parliament will positively enact a thing to be done which is unreasonable, I know of no power that can control it. And the examples usually alleged in support of this sense of the rule do none of them prove that where the main object of a statute is unreasonable, the judges are at liberty to reject it, for that were to set the judicial power above that of the legislature, which would be subversive of all government. So here is Sir William Blackstone saying, I know it's a rule that parliamentary acts contrary to reason are void, but if they positively enact it, that means if they enact it in a statute, and they tell you to do something unreasonable, I know of no power that can control it. And by the way, idea, if you want to take this to its absurd conclusion, people will point out that Parliament is so supreme that should it enact that the grass is blue and the sky green, then the grass is blue and the sky green. So Blackstone sides firmly with the notion of legislative supremacy, and he refuses to allow judges to have a censorial role. But Blackstone was also aware that it was an absurdity to assume that judges could simply enforce all statutes. After all, statutes sometimes contradicted one another. Sometimes they contradict themselves. Sometimes laws are written by idiots. Blackstone may have supported parliamentary supremacy, but he did not hold individual members of Parliament in high regard. So part of what Blackstone was doing was creating a new set of rules for statutory construction. Blackstone laid down the following rules of interpretation. And these are located, by the way, in his commentaries to the laws of England. And there should be a link to these. They're on the Avalon site at Yale Law School. So it's very easy to find this, and I'll put a link up to them. But he provides these rules. You need to think about how these rules are actually going to constrain precisely what it is that parliamentary sovereignty means. We start here with this. All remedial statute, that is, all statutes that provide remedies for wrongs, are to be interpreted reasonably according to these three things. What was the old law? What was the mischief that the law remedied? And what is the remedy? And the law shall always be interpreted to effect these ends. So if a statute is written in such a way as to be ambiguous, or if it reads to be absurd, the way judges should interpret it should always be to affect the purpose of the law. And these are a set of rules that get you there. If it is a remedial statute, then you look to these three things to determine how to interpret it. Here's another rule. A statute which treats people or things of an inferior rank cannot be presumed to extend to things superior to it. For example, a statute dealing with parsons and vicars should not be held to extend to bishops. Third, penal statutes shall be construed strictly. And he makes an example here. He says, a recent statute making it a felony to steal sheep, quote, or other cattle, end quote, was actually held by judges to be too vague. And so other cattle was given no meaning at law. In other words, the statute was read only as creating a felony out of the stealing of sheep. So in that way, Parliament might have meant something different, but judges are to interpret it reasonably. There are some other rules here. We can go through some of them quickly. Statutes against frauds are to be interpreted liberally, even though this seems to contradict the previous rule because a statute against fraud is in fact a penal statute. But he points out that this is so because the purpose of frauds is to protect people who are defrauded. So that's why statutes against fraud should be interpreted liberally, while all other penal statutes interpreted strictly. If a statute is self-contradictory, then the interpretation that best allows the whole statute to stand will be given to it. And then there's actually a set of other rules that I did not include in here. And you can read them if you like. But other very important rules were that common law gives way to a statute, that is, statutory law supersedes common law. If a statute repeals another statute, and then that statute is repealed, the first statute is revived, even if there is no express mention of the revival. So in this way, judges can infer a revival of a statute that had been superseded by another statute. The last in time rule also applies. So whatever the last statute passed is obviously the one that holds. And it's assumed to repeal previous statutes, even if there's no express mention of the repeal. Parliament cannot bind future parliaments. So Parliament cannot say that something cannot be done by a future Parliament. That simply cannot be done. You can never bind the sovereign body of the people. Finally, acts of Parliament that are impossible to perform are of no validity. And you can all imagine things that would be impossible to perform, and judges simply are told that they don't have to actually follow these statutes. So think about these rules and about what this means in terms of judicial independence and legislative supremacy. The rules of statutory interpretation are actually pretty firm, but there's plenty of play in the joints here. In other words, there still is room for judicial discretion, even though judicial discretion has been tremendously curbed and parliamentary sovereignty has been firmly established by the 18th century. But that discretion could not be arbitrary or capricious. it had to be reasonable, and it had to be bound by the rules.